What is international law? International law is the set of rules and principles that govern the relationships and interactions among sovereign states, international organizations, and, in some cases, individuals. It provides the legal framework for cooperation, conflict resolution, and global governance, addressing critical issues such as peace and security, trade, human rights, environmental protection, and the law of the sea. Unlike domestic law, international law lacks a centralized authority or enforcement mechanism. Instead, it is based on the consent of states, which agree to abide by rules that benefit their collective interests. The origins of international law can be traced back to ancient agreements between city-states and empires, but its modern form began to emerge in the 17th century with the Peace of Westphalia, 1648. This treaty established the principles of state sovereignty and equality, which remain central to international law today. Key terms in international law. Understanding the foundational terms of international law is essential to grasp its scope and application. 1. Sovereignty is the principle that each state has the right to govern its territory and population without interference from others. It underscores the equality of all states in the international system, regardless of their size or power. However, sovereignty is not absolute. It is limited by international obligations and norms. Example, the principle of sovereignty was emphasized in the Island of Palmas case, 1928. The Permanent Court of Arbitration ruled in favor of the Netherlands over the U.S. in a territorial dispute, highlighting the importance of effective control over claimed territories. 2. Treaty. A treaty is a formal, written agreement between two or more states or international organizations, legally binding under international law. Treaties address various issues, including disarmament, trade, and environmental conservation. Examples: the Treaty of Versailles, 1919, ended World War I and imposed significant reparations on Germany. The Kyoto Protocol, 1997, and the Paris Agreement, 2015, focus on reducing greenhouse gas emissions to combat climate change. Customary international law. Customary international law develops over time through consistent state practices, combined with the belief that such practices are legally obligatory, opinio juris. It is binding on all states, even those that have not explicitly agreed to specific treaties. Example: the prohibition of genocide, slavery, and piracy are recognized as customary international laws. 4. Jurisdiction. Jurisdiction refers to a state's or court's authority to apply and enforce laws. It can be territorial, within a state's borders, extraterritorial, beyond its borders, or universal, for crimes like genocide or piracy. Example: the Lotus case, 1927, involved a jurisdictional dispute between France and Turkey over a maritime incident, setting precedents for extraterritorial jurisdiction. 5. State responsibility. States are accountable for their actions under international law, particularly when they violate obligations owed to other states or the international community. Example: the Corfu Channel case, 1949, held Albania responsible for damages caused to British ships in its waters, reinforcing the principle of state responsibility. 6. Use of force. The use of force by states is strictly regulated by the United Nations Charter. Article 2.4 prohibits the use of force except in self-defense or with Security Council authorization. Example: the U.S.-led invasion of Iraq in 2003 lacked clear authorization under international law, sparking widespread criticism. 7. International organizations. International organizations, such as the United Nations, UN, play a critical role in the development and enforcement of international law. They provide platforms for negotiation, dispute resolution, and norm setting. Example: the UN Convention on the Law of the Sea governs maritime activities, ensuring freedom of navigation and resolving disputes over territorial waters. Sources of international law. The sources of international law, as outlined in Article 38 of the Statute of the ICJ, include: 1. Treaties. Treaties are the most formal and direct source of international law. They establish specific rules that bind signatory states. Example: the Geneva Conventions, 1949, established the rules of war and protect civilians and combatants in armed conflicts. Customary international law. Customary law emerges from the consistent practices of states over time, reinforced by a belief in their legal obligation. It fills gaps where treaties do not exist. Example, the principle of diplomatic immunity, where diplomats are not subject to the jurisdiction of the host state, is derived from customary law. 3. General principles of law. These are legal principles common to major legal systems and include notions like good faith, equity, and justice. Example, the principle of pacta sunt servanda, agreements must be kept, is fundamental to the enforcement of treaties. 4. Judicial decisions and scholarly opinions. Decisions by international courts and writings by legal experts help clarify and evolve international law. Example, ICJ rulings, such as the advisory opinion on the legality of the threat or use of nuclear weapons, 1996, contribute to legal clarity. Functions of international law. 1. Maintaining peace and security. International law aims to prevent conflicts and regulate the use of force. Example, the UN Charter prohibits aggressive wars and encourages peaceful dispute resolution through mechanisms like arbitration and mediation. 2. Facilitating international cooperation. It provides a legal framework for cooperation on issues like trade, environmental conservation, and global health. Example, the World Health Organization, WHO, plays a key role in managing pandemics, as seen during the COVID-19 crisis. Protecting human rights. Human rights law protects individuals and groups from abuses. Instruments like the Universal Declaration of Human Rights, UDHR, and the International Covenant on Civil and Political Rights, ICCPR, set global standards. Example, the European Court of Human Rights enforces human rights laws in Europe, holding states accountable for violations. Resolving disputes. International courts and arbitration bodies help resolve disputes between states peacefully. Example, the South China Sea Arbitration, 2016, addressed territorial disputes in the South China Sea under UNCLOS. Challenges to international law. 1. Enforcement issues. International law lacks a centralized enforcement mechanism, relying on states to voluntarily comply. Example, despite ICJ rulings, the U.S. ignored the decision in the Nicaragua case, 1986, highlighting enforcement challenges. 2. Sovereignty versus international obligations. Tensions often arise between a state's sovereignty and its international obligations. Example, India and Pakistan's resistance to the ICC stems from concerns about sovereignty. 3. Power dynamics. Powerful states sometimes manipulate or disregard international law to pursue their interests. Example, the U.S. invasion of Iraq, 2003, was widely criticized as a violation of international law. 4. Emerging issues. New challenges, such as cyber warfare, climate change, and space exploration, require updated legal frameworks. Example, the Tallinn Manual on International Law, applicable to cyber warfare, provides guidelines, but binding treaties are still lacking. International law and practice. 1. Environmental protection. Treaties like the Paris Agreement show how international law addresses global challenges like climate change. 2. Humanitarian intervention. International law balances sovereignty with the need to prevent atrocities. The responsibility to protect, R2P doctrine, aims to prevent genocide and crimes against humanity. Example, NATO's intervention in Kosovo, 1999, was controversial but highlighted the humanitarian dimension of international law. 3. Global trade. The World Trade Organization, WTO, regulates trade disputes and ensures fair practices. Example, the U.S.-China trade conflict has been mediated through WTO mechanisms. Conclusion. International law is an essential framework for promoting peace, justice, and cooperation in an interconnected world. It evolves through treaties, customs, and principles to address new challenges and foster stability. While it faces enforcement issues and political challenges, its role in resolving disputes, protecting human rights, and addressing global problems remains indispensable. By understanding and strengthening international law, the global community can better navigate the complexities of modern international relations and work toward a more equitable and secure world.